So many Canadians escape to so-called cottage country as a place to relax and immerse themselves in the natural landscape. But in the past decade, several areas have seen legal battles between cottagers and Indigenous communities who own the land. The most recent case is near Regina and Crooked Lake. Cottagers are fighting a First Nations group over a move to raise the rent on the land up to 700%. Joining us now with more on this is lawyer and partner at Weir Folds, Jill Dougherty. Good to have you with us this morning. So how are the rights of these two groups determined?
Well, the rights of the First Nation are in part set out in the Indian Act, which contemplates that if they're going to lease land on a reserve, they've got to surrender or designate it, and it is leased on their behalf by the federal government. The rights are also governed, though, by the terms of the leases. And in many cases, the federal government may have delegated back to the First Nation the ability to administer the leases, deal with lease renewals, and also deal with rent increases.
So let's talk specifically about that example in Crooked Lake. We're talking about rent increases that could go up to 700%. How is that value calculated?
Well, it's very contentious because, again, you have to go back to the terms of the lease. So the Crooked Lake leases contemplate that the rental is going to be determined based upon the fair market value of the lots. Now, there was already a round of litigation between the Crooked Lake cottagers and the federal government back in 2016 that resulted in a court decision on the previous 5-year period of the lease, but they're now disputing the next 5-year period of the lease. So the thing that makes it challenging is that the lease contemplates that they're going to calculate rent based upon the fair market value of the lots. But how do you determine the fair market value of a lot on a First Nations reserve? Because the courts have said that you can't simply take comparables necessarily from the surrounding off-reserve area and say, well, if an off-reserve lot has a value of X, then the value would be same for on-reserve. What the courts have said is that there is a reserve factor, they've called it, that reflects the market perception of some uncertainty relating to leasing lots on a reserve. Now, whether that's legitimate or not is another thing, but the market is viewed as reflecting some uncertainty about the value of those lots.
Now, you worked on a case in Georgian Bay representing a group of cottagers. What can you tell me about that case?
I worked on a couple of cases in Georgian Bay. One was relating to a group of cottagers who were contesting a rent increase. So there was a similar dispute. How should you calculate the extent of the rent increase? And also, had the First Nation and had the federal government gone through the steps to properly impose that rent increase. So we ended up in federal court litigating about whether the process was right and whether the rent increase was correctly calculated. And often you get into competing appraisal evidence, like the Crooked Lake cottagers, where you have one appraiser saying, well, the value of the lots is X, based upon looking at off-reserve values, and a competing appraiser saying, no, it is significantly less or significantly more.
What was the outcome in the Georgian Bay?
Well, in both of them, we reached a confidential out-of-court settlement so in one, they were able to resolve what the appropriate rent increase should be. In the other case, the dispute was really about the provision that's in many of these leases that says, if the lease comes to an end and the First Nation is not going to rent the lands anymore, can you remove your cottages from the land? Many of the leases say, yes, not only can you, but you're required to remove whatever you've built there and remediate the land.
Oh, interesting.
So in that case, too, there was a resolution. Reached. The cottagers ended up leaving their cottages on the
land.
Yes.
Are we going to see more cases like this, do you think, in the courts?
I think yes, because many of these leases are long-term leases. They provide for rents to be increased.
We're talking long-term. How long are we talking?
We can be talking 15 years, 30 years in some cases. Many of them were leases that were established many years ago, so the annual or 5-year rent increases continue to be an issue. And in many cases, you have cottagers who may have been on the lands for 15, 20 years even, may have some significant improvements on the land, and a lease that says, if the leasing comes to an end, you're required to, or you may remove the cottage, and you're required to remediate the land. So the short answer is yes. I think you're going to continue to see these disputes.
So this conversation will continue. Jill, thanks for being here this morning.
Thank you for having me.